nice regulation made with cost. The perfect man for this job. I'm going to turn the stage over to him. He's going to talk. With 7:30, 8:30. Okay, Professor MacIntosh, the floor is yours. Thank you very much, Will. Can everybody hear me okay? Okay, excellent. Okay. So I've been at the Faculty of Law almost longer than I can remember, since the early 1980s, believe it or not. Uh, and I teach corporate law, I teach securities law, and I also teach a course called Financing the Small High-Tech Firm. And I've been involved in a number of startups. Um, Today, we're going to talk about what is undoubtedly the most contentious issue in corporate law, which is what is the function of corporations in society? And what I'm going to do is talk about the classical paradigm, which is shareholder wealth maximization, and then I'm also going to talk about the sort of more recent innovations in corporate law and outside of corporate law, leading to something which is often called stakeholder theory. So here we are. First and most important question of corporate law: why does the corporation exist? What is its role in society? Uh, Again, the traditional view is maximization of shareholder wealth. More recently, there's this strong competitor, maximization of societal welfare or stakeholder theory. Now, the bottom bullet point here is there's an elephant in the room, which is you probably know what corporate externalities are. Um, Externalities are caused, well, it doesn't have to be a corporation that causes an externality, but inflicting the cost on someone outside the corporation that the corporation is not paying for. So, for example, let's say Inco puts sulfur dioxide into the air in Sudbury. That causes acid rain all over Ontario and New York State, even into the Maritimes. And Inco is not responsible for that, for paying for that damage. That's a negative externality. There are estimates that corporate negative externalities around the world may be as high as $5 trillion per year. Now, if you've taken elementary economics, you know externalities are bad because they encourage people to do things at a level they shouldn't be doing them because they're creating these costs for others that they're not paying for. So that's kind of the elephant in the room. Now, the corporation has many, many different constituencies involved or that have some kind of relationship to it. So shareholders are a natural constituency you might think of. Uh, Trade creditors, those are people who might deliver chairs or tables or offer services to corporations. Um, they are another constituency. Bondholders, and by the way, we're going to go through the rights of shareholders and bondholders in just a minute. Bondholders and other lenders like banks. Employees are obviously a constituency that is whose welfare is very affected by what the corporation does. Competitors, government is tax collectors, consumers obviously are very affected by corporate decisions. In the environment, that's a real hot button. We'll mention ESG, and the E in ESG is environment. Uh, and as I just mentioned, uh, some of the concern about what corporations do, or a lot of the concern about what corporations do, has been in relation to environmental damage that is created by corporations. Um, okay. Uh, Society at large. Society at large. society is, you can probably think of many other constituencies uh, that whose welfare is influenced by the corporation. So again, the fundamental problem is when directors and officers make strategic decisions about what the corporation is due, who should they have regard to? Um, again, the two competing paradigms are shareholder wealth maximization and stakeholder theory. So we're going to start off with the first one, the classical paradigm, shareholder wealth maximization. And you'll note how long that prevailed from the 1860s, that is the dawn of corporate law, right up to the early 2000s, when the Supreme Court of Canada passed a couple of judgments that rejected shareholder wealth maximization. So I'm just going to go, first of all, through the rights of the different constituencies, well, some of the different constituencies. Shareholders, we'll start with shareholders. Shareholders traditionally, and certainly in the classical paradigm, are regarded as the owners of the corporation. It is shareholders and only shareholders who elect directors each year. It is also shareholders and only shareholders who are required to approve major corporate transactions. Now, the next two lines are going to have very great importance in our subsequent discussion. Shareholders are the only class of what we call residual claimant. So, for example, when the corporation is a going concern and the board of directors wants to pay dividends, uh, the common shareholders are entitled to dividends only after the debt holders are paid any interest and principal that is owing to them, and only after the preferred shareholders are paid any preferred dividend that is owed to them. Only then can the shareholders get paid, so they're last in priority. But by saying they're residual takers, what we mean is that they can be paid in dividends all the rest of the corporate profits, all that remains after the higher ranking constituencies, again, debt holders and preferred shareholders have been paid off. Now that's going to loom very large in our subsequent discussion of whether or not we should embrace shareholder wealth maximization or not. Shareholders are also the only constituency that is a residual constituency in relation to assets unwinding up. So what we mean there is, suppose the corporation's existence is terminated. Corporation has some assets. It's now going to distribute those assets to different constituencies. The first constituency in line, again, would be the debt holders, the bond holders, the trade creditors, and so on and so forth. They have to get paid first. Then the preferred shareholders get paid what they initially invested in the corporation. And then finally, at the bottom of the priority queue are common shareholders. But once again, they get all of the assets that are left over. So the prior ranking constituencies, again, the debt holders and the preferred shareholders are what we call fixed claimants. Only the shareholders are residual claimants that get everything that's left over after the ones above them are paid off. Oops. Okay, I've done something funny here. Okay. Preferred shareholders are, oops, yeah, preferred shareholders are the next constituency I want to discuss. Preferred shareholders, they're called preferreds because they have dividend rights that must be honored before any dividends are paid to the common shares. And they are also preferred, as I mentioned, should there be a winding up or a termination of the corporate existence, they must be repaid what they invested in the corporation before the common shareholders get anything. So that's why we call them preferred shareholders. However, perhaps the most important thing for today's discussion about the preferreds is that they are a fixed claim. Um, they're only entitled to a certain fixed dividend, and no matter how profitable the corporation is, and once that is paid, then the Common shareholders can be paid dividends. And they're only entitled to their return of investment should the corporation be wound up. So they are fixed claims. So that's kind of important. Oops, I did it again. Okay, what about the debt holders? Okay, so those are people that the corporation owes money. So that would include bondholders. So bondholders, when they purchase their bonds, uh, pay a certain amount into the company, and the company promises to pay them interest each period when after the bonds are outstanding, when the bonds are outstanding, and then on some terminal date repay the principal. So that's the rights of debt holders. That includes bondholders, trade creditors, banks, other people who lend money to the corporation. Again, as I mentioned, they're entitled only to interest and return of principal. So once again, they're not residual claimants. They are fixed claimants. Um, so keep on hitting the wrong button here. Okay. So those are the three most important constituents from a financial point of view, and their relative priorities in the payment of dividends on the one hand, dividends or interest, and return of assets and winding up on the other. Now, what about the directors? Switch gears here and look at directors and officers. So the directors are elected by the shareholders and only by the shareholders. And in the traditional or classical paradigm, the function of directors is to maximize shareholder wealth. That's their mission in life. They're trying to generate profits for the shareholders. In other words, drive the share price as high as they possibly can. If they don't do that, then they can be sued by the shareholders and perhaps have to pay damages to the shareholders. Um, the most important functions of the directors are appointing the officers of the corporation, the senior management team, so the CEO, Chief Executive Officer, CFO, Chief Financial Officer, and so on and so forth. And they make strategic decisions. Directors are not involved in the day-to-day running of the corporation. Rather, they sort of create a strategic roadmap for the corporation's business strategy, essentially. Um, okay, now, whoops, officers. The officers, as I mentioned, are appointed by the directors. And their duty is the same as directors in the classical paradigm. They have to maximize shareholder wealth, and they are responsible for the day-to-day running of the corporation. So that's in a nutshell what we what we call the corporate governance structure. Shareholders elect directors, directors appoint officers, and at least in the classical paradigm, the function of directors and officers, the fiduciary duty, as it's called, and I'll come back to that in a second, is to generate profits for shareholders. So here we go. Mechanism for implementing the classical view is what we call the fiduciary duty. By fiduciary duty, all we mean really is who are the directors and officers ultimately responsible to. Now, what I've done here is I've taken a section out of the CBCA, that stands for Canada Business Corporations Act, and this defines the fiduciary duty both of directors and officers. So you notice it says every director and officer of a corporation in exercising their powers and discharging their duties shall act honestly and in good faith with a view to the best interests of the corporation. So that is the nature of the duty. And you notice it says the best interests of the corporation. It doesn't say the best interest of the shareholders. Nonetheless, in the classical view, and again, this is going back like 150 years, first in England and then in Canada, the courts uniformly said that the corporation really meant the shareholders. So again, the statutory charging section that creates the fiduciary duty does say it's owed to the corporation, but in the classical paradigm that prevailed up until the early 2000s, that was interpreted to mean the shareholders. I thought I'd talk about this case a little bit. This is kind of a fun case. Dodge and Ford Motor Company. This is often cited as one of the key cases establishing the shareholder wealth maximization paradigm. Henry Ford started Ford Motor Company in 1903 with a $100,000 investment. Short period of years, they were making millions of dollars in profits, and millions of dollars back in the early 1900s. That was a lot of money. Okay, up until 1916, Ford paid out very handsome dividends, 1.2 million per year as a regular dividend and an additional 41 million as special dividends. So it wasn't just Henry Ford who was getting rich, it was the other shareholders as well. Now, in 1916, they had $54 million in the bank. That'd be a pretty handsome figure for a corporation these days. And the projected profit for 1916 was $60 million, really staggering sums in the early part of the 20th century. Okay, then what happened? In 1916, Ford abruptly announced it would no longer pay dividends. Now, it was the board of directors that made that decision, but the board of directors was under the thumb of Henry Ford. Uh, Even though the capital projects approved by the board amounted to no more than 20 million. So they had a lot of money in the bank that they weren't going to spend on capital projects. By capital projects, we mean like new buildings and trucks and so on and so forth. Okay, now that uh, plan, the plan that Henry Ford came up with was to actually lower the price of cars, not increase the price of cars, but lower the price of cars. And he acknowledged that that would reduce profitability and the share price. As the second bullet point says there, he admits that this will result in a company that is less profitable than it is admitted it might be made. Um, and from the case, the court said the apparent immediate effect will be to diminish the value of shares and the returns to shareholders. And this is Henry Ford's ostensible reason for lowering the price of automobiles. My ambition, said Mr. Ford, is to employ still more men to spread the benefits of this industrial system to the greatest possible number, to help them build up their lives and their homes. To do this, we are putting the greatest share of our profits back in the business. So this is kind of a version of a chicken in every pot, except it's a Ford Model T in every driveway. Now, the court bought his story. They said, yeah, okay, we understand that this is what you want to do. Ford Motor Company has made too much money. You're saying too large profits. You want to share that with the public and not just confer all those benefits on the shareholders. And the court said, we have no doubt that certain sentiments, philanthropic and altruistic, creditable to Mr. Ford, had large influence in determining the policy to be pursued by the Ford Motor Company, which is a way of saying Ford totally dominated the board of directors, which actually formally made the decision. Now, who is suing here? The Dodge brothers are suing. Who are the Dodge brothers? Well, we'll get back to that in a second. The court said, okay, Henry Ford, yeah, that's very commendable of you to have this philanthropic motive. But oh, by the way, corporations are run for the benefit of the shareholders, and your plan does not follow that shareholder wealth maximization injunction. So they said a business corporation is organized and carried on primarily for the profit of the stockholders. The powers of the directors are to be employed for that end. The discretion of directors is to be exercised in the choice of means to attain that end and does not extend to a change in the end itself, to the reduction of profits or to the non-distribution of profits among stockholders. Then they went on to say it's not within the lawful powers of a board of directors to shape the conduct and the affairs of a corporation for the merely incidental benefit of shareholders and the primary purpose of benefiting others. So that's a statement, it's sort of a classical, a statement of the classical view of shareholder wealth maximization. So the court, in the end, awarded or ordered the payment of dividends uh, from some of the money that the company had in the bank, which is a very rare thing for a court to do because normally the decision of what dividends to pay is a function of what the board of directors wants to do. Now, what's really interesting about this case, aside from the fact that it's illustrative of the shareholder wealth maximization paradigm, is the subtext. The Dodge brothers were big shareholders in Ford Motor Company. They had started off as its chief supplier and outside machinists. Uh, and what they wanted to do was they wanted to set up their own car company, competing with Ford. So Henry Ford knew this, and he didn't want the Dodge brothers to get a hold of the cash that they needed to start a competing company. And that's why he decided not to pay dividends, generous dividends, as the company had in previous years. Um, they did, in fact, in the end, set up their own company in 1914, which was, of course, as you know, eventually absorbed by Ford Motor Company. Uh, but that's the real reason why Henry did not want to pay out all those dividends. The irony here is if he had actually told the truth and said, I have a purely commercial reason, I don't want a competitor to come into the market, then maybe the court would have said, that's fine, you don't have to pay dividends. Okay, now, if you go to a theater uh, here in Waterloo or in Toronto or Calgary, wherever, you will often see a board listing sponsors or donors. And the donors are very frequently corporate donors. So here you have a corporation making a donation to, it could be a theater, it could be to a children's charity or a food bank or whatever. Isn't that outlawed by the shareholder wealth maximization paradigm? Well, the answer is actually no. The courts over the years held that as long as there's an indirect benefit to the corporation, then those donations would stand up. So, for example, in the first case I've got there, a New Jersey case from 1953, there was a substantial gift to Princeton University that was said to be okay because it created corporate goodwill. Well, that's a pretty indirect benefit, but for the court it was sufficient to validate the gift. The next one is an English case, Evans and Brunner, Mon, 1921. Similar kind of thing, substantial gift to Cambridge University. And the board of directors said they were making the gift because Cambridge would educate good engineers that they could then go out and hire. Well, who knows if at the end of the day they would actually hire uh, any any different people than they would have hired otherwise. But the court upheld that as sufficient indirect benefit. So even under the shareholder wealth maximization paradigm, it's important to realize that allowed corporations to make what we lawyers call ex gratia payments. Here's my favorite statement, actually, of that principle from an English Court of Appeal case from 1883. Railway company or the directors of the company might send down all the porters at a railway station to have tea in the country at the expense of the company. Why should they not? It is for the directors to judge, provided it is a matter which is reasonably incidental to the carrying on of the business of the company, and a company which always treated its employees with draconian severity and never allowed them a single inch more than the strict letter of the bond would soon find itself deserted. And this is my favorite line here. The law does not say that there are to be no cakes and ale, but there are to be no cakes and ale except as are required for the benefit of the company. Okay, so that's the classical paradigm. Then we get on to the new paradigm. And the new paradigm results again from two Supreme Court of Canada decisions, one in 2003 and the other in 2008. And they totally changed the nature of the fiduciary duty. So now instead of interpreting the corporation to mean the shareholders, the Supreme Court of Canada said um, the corporation should not be confused with any single constituency, whether shareholders or anybody else. Uh, and the duty of directors and officers, their fiduciary duty, is to seek what they called a better corporation. Now, one of the problems that people have identified with these decisions is, what does it mean to make a better corporation? It's such an incredibly vague concept. They also went on to say directors and officers must act in the best interests of the corporation, viewed as a good corporate citizen. Again, part of the problem here is, or the foundation of the problem, I guess, is, what does it mean to act as a good corporate citizen? There are probably as many different views of that as there are people in this audience tonight. So that is the recast duty. It was subsequently codified, at least to some extent, in the corporate law. Again, CBCA stands for Canada Business Corporations Act. And after the decision, this act, this section was allowed to the statute, which allows the directors in making decisions to take into account the interests of all those different constituencies, or toward the bottom there, the environment and the long-term interests of the corporation. So that is really a wholesale change in the nature of the fiduciary duty. So the question is, which of these is better? Well, I started out by saying that there are estimates of the corporate externalities of corporations that run as high as about $5 trillion a year. So we do have a problem, I think, that we have to address. We have to find some mechanism of at least reducing. I don't think we'll ever cut out the externalities, but at least reducing the externalities. And offhand, you might sort of think that, well, let's reject shareholder wealth maximization and require directors to think about other constituencies when they make their decisions, whether it's employees or creditors or the environment or whatever. That seems to kind of, at first glance, make some sense. Um, in an ideal world, I think it's fair to say that we would try to maximize sort of the global value, if you will, of the corporation, looking at the effect of corporate decisions on all of the different constituencies in an ideal world. But the problem is, in the real world, that really, for a lot of reasons that I'm going to talk about, just doesn't really seem to work. And that's going to be sort of the central part of my talk today, why it just doesn't work. I'll come back to after I've said why I don't think it does work and why we should continue to embrace shareholder wealth maximization. I will suggest that there are alternatives to changing the nature of the fiduciary duty that can help us attack some of those externalities. Problem one. Well, Supreme Court of Canada, in saying that directors and officers, in discharging their fiduciary duty, should think about more than shareholders, kind of overlooked the fact that directors are elected by shareholders and shareholders only. So, who are the directors going to feel beholden to? Naturally, they're going to feel beholden to the people who elect them, because if they don't maximize shareholder wealth, they may not get elected at the next annual meeting. So that's kind of an important factor. On this slide, I also say directors feel comfortable looking to shareholder wealth maximization, because that was the paradigm for a century and a half. Problem two, the business judgment rule. Okay, so what is the business judgment rule? Well, it's a rule in law which says if the directors and officers faithfully follow certain procedures, decision-making procedures, then they will be insulated from liability for breach of the fiduciary duty. Those decision-making procedures have always focused on shareholders. So, for example, if there is a takeover bid for a corporation, um, the directors of the target corporation, in discharging these procedural requirements, are going to have to go out and get a valuation of the corporation done by an independent third party. And that valuation is going to focus exclusively on the effect of the transaction for shareholders. Well, if you look at what is done in the marketplace today, many, many years after Peoples and BCE, these two Supreme Court of Canada decisions, that's still the practice. Uh, the old procedural requirements have carried through pretty much unaltered, even though directors and officers are supposed to consider constituencies other than shareholders. Managerial bonuses. In public corporations, typically you have some kind of incentive mechanism for directors and officers in particular, to perform well. So you might give them stock options, or you might give them shares. Almost every form of incentive compensation in a public corporation is geared to the share price, not to the welfare of other constituencies, but to the share price. Uh, and so, so who are the directors and officers going to think about when they make their decisions? Well, they're probably going to think about the shareholders once again. Hostile takeover bids. Okay, so what's the point here? If you are a public company, you have all kinds of outstanding shares. Uh, and someone can make what we call a takeover bid, which is an offer to purchase a controlling block of shares in that company. Uh, and then they can turf out the existing board of directors and senior officers. Well, if you look at the empirics on takeover bids, what we find is that if there is a hostile takeover bid, by the way, the word hostile means simply a takeover bid that is not endorsed by the target management. If there is a successful hostile takeover bid, the existing directors and officers will likely lose their jobs. Uh, and more empirics. Badly run firms, in terms of share price, are much more likely to attract hostile takeover bids. And more empirics, the best defense against a hostile takeover bid is a high share price. So what I'm describing here is a set of factors that incentivize directors and officers to look to shareholders. Now, it doesn't mean we can't change this stuff. It doesn't mean that we can't change it in some ways so that the incentives are to consider other constituencies. But I do want to point out that all of these different factors that we're looking at now strongly incentivize directors to consider only shareholders. Okay, net present value rules. Okay, you folks are biz students, so you probably know what net present value is. Uh, it's supposed to be the most important criterion in choosing between different possible investment projects. It depends entirely on present and future cash flows. So, as I say in the third bullet point, this is how in the real world managers make a better corporation. Um, now, being a good corporate citizen counts only insofar as it might conceivably relate to cash flows. So I guess the point I'm making here is the way we're training managers in biz schools, it also really looks to shareholder wealth maximization. And that hasn't changed after these two Supreme Court of Canada decisions. NPV is agnostic as to risk. So if the highest NPV project also has a great deal of risk, well, that's fine. Uh, But it's not fine under the two Supreme Court of Canada decisions because the riskiness of a given decision will affect different constituencies differently. It might be a threat, for example, to employee jobs because higher risk means, if it succeeds, it could succeed very generously, but if it fails, it could fail very seriously. In which case, maybe employees will lose their jobs. Um, and so, as long as we embrace the NPV um, criterion, then we're really looking to shareholders again. Which, once again, is not to say that we can't change this stuff, but all of this stuff really tends to incentivize directors and officers to look to shareholders. Problem 7, decision complexity. I think this may be a more serious problem from a substantive point of view. Um, the path to shareholder wealth maximization is very complex. I don't know if any of you sat on boards of directors. I have about 30 person years experience as a director. It's very, very difficult for directors to figure out the path to shareholder wealth maximization. There are all kinds of risk return combinations and permutations. So even doing looking to that one constituency is very difficult. In the last bullet point here, I say if we ask directors to go further and maximize global wealth or welfare, it becomes an n-body problem. Now, I'm borrowing the phrase n-body problem actually from astronomy or astrophysics. It's the problem of predicting how planets and moons move. It turns out to be one of the most difficult problems in physics and has only been solved for two or three celestial bodies. Above that, it just has defeated any attempts to resolve it. So the point I'm trying to make here is if the directors and officers have to consider 10 different constituencies in making a decision, it becomes just like an n-body problem. It becomes insuperably difficult. Another problem is going back to what these decisions said about the fiduciary duty, make a better corporation. Well, what's a better corporation? I mean, it's very much in the eyes of the beholder. What's a good corporate citizen? Well, it probably depends a lot on your politics. It depends very heavily, I think, on your politics, and it could mean any of many, many different things. So the legality of any given transaction is probably going to be unknown in advance because you don't know how the judge, if there's a lawsuit, how the judge is going to trade off these different factors. It may be different from the way the board of directors has traded them off. I'll come back to that in just a second. So um, when you have a shareholder wealth maximization requirement, uh, you can at least figure out kind of what you're doing. Um, but when you have this instruction to make a better corporation, you could be doing just about anything, and that really is damaging to certainty, which is very important in business. Um, another problem is, do we really want directors and officers to make what are essentially political decisions? So the thrust of stakeholder theory is that directors and officers should be trading off the interests of different constituencies in the corporation. Well, in other words, that's really not an efficiency function; it's a redistributional function. And I guess the point that I'm trying to make here is that directors and officers are not necessarily the kind of people who we want to make those decisions. As I say here, directors and officers are not a representative slice of the population. They tend to be older white males. And there's a big movement on now to achieve more diversity in boards, and it's certainly changing the profiles of boards. But I think it's really fair to say that most corporate boards are still dominated by older white males. Now, do we really want those people making distributional decisions? Why not let corporations make profits? tax away the profits and then let the government decide how to spend that money. The government at least is accountable to voters. So you have a group of people who are accountable making redistributional decisions, whether it's in regard to employees or creditors, the environment. Let corporations do what they do best, which is make money, tax it away, and then use the tax revenues to accomplish those social goals that you want to accomplish. Same criticism about judges. Do we really want judges, excuse me, to make political decisions? Because when judges are called upon to review the propriety of board action, let's say, which has traded off different constituencies one against the other, the judge may have a different political persuasion and maybe say, well, you should have treated employees a little bit better. I'm really big on protecting employees. Whereas the board of directors might have said, well, we're bigger on protecting the environment or something like that. Again, that just creates a lot of uncertainty, especially because, the directors and officers' politics may be different from that of judges. I guess my view is we really should take politics out of the corporation and out of corporate law and put it in the hands of politicians. Again, tax away profits and let politicians decide which constituencies are worthy of supporting in one way or another. Oops, there it goes again. Okay, now this is also a big problem here. I think if I had to reduce this problem to a sentence, it would be that responsibility to everyone ends up being responsibility to no one. That is, if you have uh, uh, a, uh, a rule that says that in making decisions, the board can look at any of 10 or 12 different constituencies, uh, they can always support any self-serving decision that they might make on the basis that it was in the interest of some constituency or other. Um, I've put two examples down here: hostile takeover bids, which I think are kind of a good example. A hostile takeover bid, again, is a takeover bid by some third party seeking to get a controlling share interest in a corporation. And then when they succeed, perhaps turfing out the incumbent directors and officers. Well, of course, the directors and officers are not going to want that to happen. So they may fight off a takeover bid, not because it's not good for shareholders, but because it's not good for them. In other words, there's a really fundamental conflict of interest when there's a hostile takeover bid. If you have this multi-pronged fiduciary duty, the directors can simply cook up some kind of plausible story uh, that they fought off a takeover bid, not for themselves, but let's say for the employees or for the creditors or for the environment or whatever. So what it leads to is more freedom for directors and officers to feather their own nests at the expense of not only the shareholders but all other corporate constituents. The Romano study that I referred to at the bottom there was an interesting study done by Roberta Romano at Yale University. And what she looked at was situations in the United States where corporations had lobbied their legislatures to allow directors to consider the interests of employees and other constituencies if there was a hostile takeover. So what Roberta did was she looked at where the impetus for that lobbying came from, and what she discovered was that in every single case, it was because the corporation that was doing the lobbying was likely going to be the subject of a hostile takeover bid. Either there had been a hostile takeover bid already, or it looked like there would be one. So they lobbied the legislatures to say, let us consider employees and creditors and so on and so forth. They weren't remotely interested in the welfare of employees or creditors. they were interested in being able to cook up some kind of story that would allow them to dodge their fiduciary duty simply by saying that they were acting in the best interest of the employees or the creditors. Okay, so innovation and risk taking. I think this is an important point too. What I've done here is I've got put together sort of a little model, one period model. Employees have a fixed claim of 10, and that's to be paid at the end of the period. It's just a one period, 1 year model. Directors choose an investment project at time zero, so at the outset. There's $10 in the corporate treasury, and all investment projects cost $10. And as we'll see in a second, there are a variety of investment projects. They have different payoff distributions over the 5 possible and equally probable states of the world. So, um, okay, for some reason that's, oh, there we go. Okay, so here's our matrix of payoff. So across the top, you have 1, 2, 3, 4, 5. Those are the different possible states of the world that could come about. They each have a 20% probability. And you can see on the left side there are 3 investments, investment A, B, and C. And if you go across each of the rows, you can see what the payoffs are in each of those different states of the world. The payoff distributions are quite different. So, for example, for investment A in states of the world 1, 2, 3, and 4, the payoff is $10. In the 5th state of the world, it's only 5. Investment B is very different. In 4 states of the world, there's no payoff, no return at all. But in state 5 of the world, there's a $1,000 payoff, so very risky. Investment C is different from either A or B. In some states of the world, you get pretty good payoffs, like 4 and 5. In state 1, you get no payoff whatsoever. Um, Now, what's the point of this? Well, what I want to do is compute the expected values of the different projects, first from the shareholder's point of view, and then from the employee's point of view. So expected values from the shareholder's point of view. Remember, the shareholders are residual takers. So after the employees are paid their $10, they get everything else. Uh, Investment A, you'll see just weighting those 5 different possible outcomes. The value is expected value is $9. Although at the bottom you'll see that $9 doesn't subtract out the $10 employee pay stream. Investment B, again, you can see the expected value is $200. Even though it's highly risky, it pays off only in 1 state of the world. Investment C, the expected payout is $14. And then last 2 bullet points here. After payment of the employee's $10 fixed claim, the values are minus $1, $190, and $4. So if we're looking at this from the shareholder's point of view as residual takers, it's easy to rank order them. The rank ordering is the preferences on B, and then C, and then A. So the preference is on B, even though B is by far and away the most risky of all of these options. Well, you can do the same from the employee's perspective. Um, the employees never get more than their $10. Again, they have a fixed claim. So we can look at the value to them in these different states of the world. So again, just 20% times each of the different 5 outcomes. So investment A from the employee's perspective has a value of 9. Investment B only $2 because in the state 5 of the world where the payoff is 1,000, they only get their $10 because they have a fixed claim. Investment C, the value is $6. So in order, the employees will choose investments A, C, and B. Now that's the exact opposite to the shareholder's preference. Remember, the shareholder's preference um, is B, C, and then A. Here, the preference is A, C, and then B. Um, Now, the point here is that the fixed claimants have an incentive to take really very little risk, as little risk as possible. What they're primarily concerned about, whoops, let me skip one over. Um, Okay. Um, they have an incentive to simply get paid their $10. No matter how profitable the corporation is, they never get more than $10. And so that's why their preferences line up the way they do, uh, and why they line up so differently from the shareholders. And this comes back to this really important point that I made at the outset, that the shareholders are the only class of residual taker. So when in state five of the world, the payoff is 1,000, they keep all of that 1,000 except the $10 that's due to the employees. And so what that means, well, this creates a couple of problems. First of all, how do the directors reconcile those different interests? Now, hopefully, in a real world situation, there would be more and more varied opportunities that the directors might choose from. But the point is, it's really very difficult to think of how directors, as a practical matter, are going to trade off the interests of the residual constituent against the fixed claims. They really have very fundamentally different interests. And here's, I guess, the most important bottom line. Um, if we want our corporations to take any significant degree of risk, then basically we have to embrace shareholder wealth maximization. We have to embrace the directors acting in favor of the residual claimant, not the fixed claimants. If you have boards of directors acting for fixed claimants or perhaps some combination of fixed and residual, you're likely to get a heck of a lot less innovation, because innovation requires taking risk. You know, out of 10 tech startups, for example, there we have some pretty good statistics that out of any given set of 10 tech startups, 9 will fail. These, these small tech businesses are very risky, but you wouldn't have probably any of those tech businesses at all if you had the directors acting in favor of the fixed claimants. So, how do we address externalities? I don't by any means wish to minimize this problem of externalities. In fact, it's a huge problem. There are corporations out there that one of my colleagues out at UBC wrote a book which basically said big corporations behave like psychopaths a lot of the time, and he's right. They do often behave like psychopaths. Um, but for me, the solution to that is not to have a bifurcated or a complicated fiduciary duty for directors to follow, and one that focuses on the fixed claims. Now, in fact, when we consider the kinds of constituencies that people typically point to as those who should be considered by directors in making their decisions, we find that there is loads of regulation out there, loads of legislative acts that protect these people already. So, employees, Labor Relations Act, Employment Standards Act. Labor Relations Act, so for example, governs collective bargaining and sets down a complex set of rules governing that. Employment Standards Act, Occupational Health and Safety Act, so safety in the workplace, what you have to do to keep your employees safe and healthy and out of harm's way. The Human Rights Code. Um, so there's lots of stuff out there already that protects employees, and importantly, this stuff is put in place by politicians who must answer to us at the ballot box. And if we don't think that employees are being properly treated, we can make a big deal out of that and maybe elect some different politicians. What about trade creditors? They're often said to be a vulnerable constituency, and I think they are quite vulnerable. But there's all kinds of law that protects them as well. Contract law, the enormous edifice of contract law, property law, agency law. We have something called the Sale of Goods Act that governs the sale of goods, as you might imagine, to whomever. Something called the Personal Property Security Act. The point I'm making here is just that there is lots of legislation. And if we think that that is inadequate, we can always add more legislation. Now, I was actually a little surprised myself when I got into looking at how many statutes there are that deal with the environment. This is not a complete enumeration. Every province has an Environmental Protection Act, and so does the federal government. Ontario has a Water Resources Act. And then look at all these different federal statutes: Department of the Environment Act, Fisheries Act, Antarctic Environmental Protection Act, Arctic Waters Pollution Protection Act. To my mind, a legislature is going to do a much better job of defining what is appropriate and what is inappropriate and making sure it is enforced than a board of directors. You know, I don't know why we would want to put faith in the boards of directors of big corporations to protect the Antarctic environment or the Arctic environment. I just, if we do that, I don't think it's going to happen. Because for all of the reasons that I mentioned, boards of directors really are still focused on shareholders. And maybe we can change some of those incentives on directors and officers. But the reality is today, many, many years after these two Supreme Court of Canada decisions, there's absolutely no doubt that boards of directors are still shareholder wealth maximizing, despite ESG, which I'll get into in a minute. Okay. We actually have some new legislation that deals with diversity as well. Diversity has become a major issue. Diversity on boards of directors, diversity amongst employees. Well, now the Ontario government has gotten into the act through certain provisions in the Ontario Securities Act, which require public companies to disclose their policies on diversity and how they aim to achieve diversity. If we want to achieve diversity, that's a much better way than leaving it up to corporations, to my mind. Uh, these are obviously not perfect. Legislatures make mistakes. Legislatures are subject to public interest pressures, including pressures from corporations. But I guess what I'm trying to say is it seems to me that it's a lot more effective to have this kind of control over corporate externalities than putting faith in a bunch of old white men. For me, that's kind of what it comes down to. Okay, finally, we get to ESG. Um, ESG is all the rage right now. In the last few years, many, many companies have started up that give ratings that rate public companies on ESG. ESG, remember, is environment, social, and governance. And the one thrust of ESG is to make corporations socially responsible by inculcating a socially responsible mindset amongst corporate leaders, affecting the corporate cost of capital through the exercise of investment preferences. So if you can, if investors shun certain companies that are, say, socially irresponsible, that will drive their cost of capital up and make it more difficult for them to carry on business. And the last bullet point here is also acting on the basis of ESG ratings. Consumers can make decisions. I'll buy from this corporation because they have a good ESG rating. I won't buy from that corporation. Now, uh, another thrust under the ESG banner is that there are a lot of mutual funds now that build themselves as ESG funds. So come invest your money with us. We will take your money and turn it around and invest only in companies with high ESG ratings. So that's another thing that comes under the ESG banner. Okay, as I mentioned, you can purchase ESG ratings on thousands of companies. So I've just trotted out a few here. Data Emporium has ESG ratings on 7,300 companies. Refinitiv on thousands. I couldn't get an exact figure. S&P Global, 7,300 public companies, and so on and so forth. So there are lots of people now who are selling these ESG ratings and also offering corporations services in, how do you get a better ESG rating? And they're making, so far as I can tell, quite a bit of money. Now, one problem with that, as I've noted at the bottom here, is I think there are unfortunately a lot of problems with these ESG ratings as it stands right now. You typically get an overall ESG rating. That doesn't tell you how each company performed in each silo. So, say you're really concerned about the environment. Well, you can't see which part of the ESG rating comes from the environment. Or let's say you're concerned more about social stuff. Perhaps where does the company source its garments? Does it use child labor or something like that? Uh, you don't know how much of the overall ESG rating comes from the S in ESG. Um, so you get an overall rating. Another big problem is that these companies that are doing these ESG ratings don't tell you what their criteria are. They're all secret. So I pulled this off Data Emporium's website. It says nearly 1,000 data points are assessed for each participating firm, but they don't tell you what they are. So you can't see if they're good points or bad points. Goes on to say up to 120 relevant questions are answered and we evaluate the responses. You don't know what the questions are, don't know if they're asking the right questions, and so on and so forth. Nearly 30 different criteria used to parse the insights. They don't tell you what those 30 different criteria are. So, you got all of these different companies doing ESG ratings. They often disagree with one another, because who knows, again, it kind of goes back to what's a better corporation or what's a good corporate citizen. Uh, you know, uh, the E and the S and the G can make they can embrace so many different things and so many different criteria. It depends on very much on the eye of the beholder. Okay, so yeah, I've said different rating companies use their own undisclosed criteria. They don't say how they trade off E, S, and G. Okay, so I've made that point. They don't say if they're scoring on the basis of announced intentions or actual results. Now, a lot of big companies out there are saying we have really ambitious goals for reducing our carbon footprint, which is great. I think that's terrific. Unfortunately, a lot of these rating companies, so far as I can tell, are not actually looking to see if they keep their promises. Uh, and they don't engage in any verification. They often give a rating on the basis of an announced intention rather than something actually happening. So that's another problem. With ESG, SRI stands for socially responsible investing. Oops, there we go. Um, how many funds are actually involved in socially responsible or ESG investing? Well, what I've done here is I went to three different sources that purport to tell you how many total dollars of these ESG funds are under administration around the world. They're all over the map. So the first one, Wealth Professional, said worldwide ESG funds were 2 trillion in 2021, or 4.3% of all mutual fund assets. The next one, Adviso Wealth, says worldwide ESG assets totaled 40 trillion. Wow, 40 trillion versus 2 trillion. That's a huge difference. And that is 86% of all mutual fund assets. It's kind of difficult to credit that, to believe that 86% of all mutual funds out there are really ESG friendly. PricewaterhouseCoopers worldwide ESG assets were 18.4 trillion, so just about in the very middle of the other two. What's going on here? You have different estimates that are wildly different. So, do we really know what ESG is? Do we really know what these mutual funds are doing? It depends totally on what criteria you use, and these criteria are opaque. We're not told what they are. So, I guess the problem is, when you see some company with a high ESG rating, you don't know what that high ESG rating derives from, and whether or not the company's actually done anything to follow through and keep its promises. Um, Now, I thought it would be useful to have at least one slide that looks at how do ESG mutual funds perform versus others. I think it's fair to say that the vast majority of studies say that there's no performance advantage if you buy into an ESG fund. On the other hand, they also seem to say that there doesn't seem to be a performance disadvantage. But so the majority are saying that. performance is, well, no better and no worse. There's a Canadian study that shows a slight advantage in the performance of ESG funds, but unfortunately, it was funded by two ESG firm or two mutual funds that market ESGs. So I don't know how seriously we can take that result. There are also studies finding that so-called sin stocks, alcohol, tobacco, and gaming outperform ESG stocks. So if you're concerned about return, and you may not be if you're looking for ESG investments, but if you're concerned about return, uh, they return about the same as other mutual funds, which might be great. So maybe you can indulge your ESG preferences, at least if you believe the ratings and not actually suffer any investment losses. Okay. Beware of greenwashing. Um, Unfortunately, there is growing evidence that a lot of companies that have announced ambitious, say, carbon reduction programs are not following through. So they make these very extravagant announcements about we're going to reduce our carbon footprint by such and such before such and such a date. And what you tend to find is that a lot of it is just advertising, it's just touting. So I've given you a few examples here. This comes from a UK think tank called Influence Map. It found that the majority of climate positive messaging used by 5 major oil and gas companies, which are indicated there, is inconsistent with their spending on low carbon activities. So, what that means is they say, we're going to do all this wonderful stuff and we're going to spend all this money to reduce our carbon footprint, and then they don't. Most of the expenditures in this study were on touting their records and ambitions. Coca-Cola, largest plastic polluter in the world, because the soda pop comes in plastic, uh, excuse me, vessels. Nonetheless, it advertises itself as a sustainable and eco-friendly company. Well, how seriously can you take that? I mean, come on, get rid of the plastic. That plastic is super destructive on land, in oceans, everywhere. So come on, really do something. Um, uh, Not working again. Oh, again, that's why. Okay, BP. This is really lovely. BP changed its name to Beyond Petroleum. It used to be British Petroleum, Beyond Petroleum. So they want you to think of wind power, solar power, hydroelectric power, stuff that doesn't derive from petroleum. Well, 96% of their global spend is on oil and gas. So again, how seriously can you take them? A lot of this is just sort of kind of advertising. Uh, Starbucks released a strawless lid for their beverage containers in 2018, ostensibly as part of their sustainability drive. It actually contains more plastic than its predecessor. Again, just words. Okay, and that is actually the end. I guess just conclude by saying this. Um, we have a major problem in the world with corporations misbehaving and creating externalities. I think that's absolutely undeniable, and we have to find some solution to that. And what I've suggested today is that changing the fiduciary duty on directors and officers is not by any means the best way to do that. Indeed, it's not even a good way to do that. What I'm suggesting is we need perhaps more active government intervention in what corporations are doing if we feel that they are misbehaving. I guess I have a lot more faith that that will work effectively than changing the fiduciary duty of directors. Uh, there we go. Thank you. I I heard some ups and I heard some downs there. I know this is a very contentious issue, and whatever. I've said my piece. And by the way, yeah, I might just add when I'm grading my own law students, oh, save it for another time. Yeah, when I'm grading